Proof of ownership. How big of an issue is it when defending a debt lawsuit? Brought to you by yourlegallegup.com, your advantage if you are being sued by debt collectors. I get comments like this from pro se parties all too often. A debt collector got a judgment without even proving ownership of the debt. It makes me feel bad, but it makes me feel angry too. Let's talk about proof of ownership and then segue to a larger point, the point that every person being sued by a debt collector must learn. It's not hard to prove ownership in the debt law. It isn't, and it shouldn't be. For a car or a piece of real property, that is land, you just need a title, a car or a deed for land. You get them essentially by the seller giving the buyer a bill of sale, which in turn gets verified by the state. And there can be, contracts backing all of that up. But if there's a bill of sale, it gets turned into and verified by the state. The state procedures complicate things a bit, but it's basically a very simple rubber-stamped process. It's a mistake to regard this process as much of a protection for anything. Selling a debt is easier even than that. You need a bill of sale that identifies the thing being sold. That's it. Our commercial system favors a simple sales process. Now, as it happens, debt collectors sometimes do not satisfy this very simple process, or they fail to prove it anyway. How? By not identifying the thing that's being sold. A typical debt bill of sale document says, I bank, Citibank or credit, some First National Bank or whatever, hereby assign all rights to the following debts to, and then, they name the debt collector. See attachment A for the debts assigned. That's what the bill of sale will say, plus a date. Sometimes, and surprisingly often actually, the debt collector, in attempting to prove it owns the debt, neglects to attach the attachment A to its proof. That leaves the bill of sale unconnected to any specific account and thus fails to prove that the debt collector owes the debt that's in dispute. The court should always take that failure seriously, as it really does mean the debt collector didn't prove that it owned the debt, and that should be crucial. Still, you can see how it's basically a technicality, right? And you should know that the courts don't like technicalities that help people avoid debts. I take some heat for saying stuff like that. People want me to fight the system and tell them that things are different than they are because they should be different. But look, your case is not the time for me to make my political statements, is it? I make my statement by helping thousands of people beat the debt collectors and keep their stuff, and I do that by telling the truth. But to get back to what I was saying, the problem with relying on technicalities is that they're easily fixed and all too easily ignored, and sometimes the courts do ignore them. That's the reality. Now let's move a little further with the bill of sale analysis. Suppose a debt collector buys a debt and then sells it to another debt collector. That happens all the time. If either of the bills of sale neglects to attach attachment A, then you can say that the debt collector cannot prove a valid chain of title, because I can't sell a debt, or I can't sell a valid title to a debt unless I own a valid title in the first place, right? Again, though, not all courts are sensitive to the justice of this technical rule. You will be burned sometimes if this is all you depend on, even though, in my opinion, you should always win. Okay, now let's move on to the bigger issue. I just did a video called The Most Dangerous Myth for People in Debt, and it looks like it's going to be pretty popular if early indications are correct. The point I make in that video is that you cannot depend on other people, not courts, debt collectors, or opposing lawyers, or anybody else to help you. You can't depend on them to do the right thing. In the real world, what you have to do is pile up as many reasons to do the right thing as possible and hope that one of them works. That's what lawyers do. If they don't legitimately prove ownership, you should win all the time, and probably will win more than 50% of the time at least. If that's all you got, you go with it, right? But if you've got a debt collector, you know the chances are strongly against them having legitimate admissible evidence of the amount of the debt. So you learn what that all means and attack that too. They probably don't have good evidence that you owe any debt or that the original creditor ever sent you statements. So you'll learn what you need to do to attack those things too, and so on. Anytime you stop attacking before you run out of things to attack, you're depending on someone else to take care of you. And how do you know what to attack, or when, or how? By doing discovery, by probing, researching, thinking, by doing everything you can, in other words, to find out how, and to do it. Anytime you stop short of finding out every basis you have for attacking, you are trusting someone else to take care of you. Our job is to help you develop a plan of attack and follow through all the way till there's nothing left to attack. That's when you know you've done your best. And even then it's possible to lose. It's just much, much less likely. I'm creating a much longer video that takes a more systematic view of the debt collection process, what you can do, and what you're up against. You'll find that linked in the About This Video section below. For now, let me encourage you to think in terms of defending yourself by piling on as many reasons that you should win as possible. Don't look for the easiest way out. Helping people protect their rights is what we do. Protect what's yours and don't let the debt collectors rip you off. YourLegalLegUp.com